Welcome to Planning with Purpose.
Hey everybody, welcome into an all-new episode of Planning with Purpose with attorney Deb Morneau of Courteous Law PC out in Henniker, New Hampshire. I am your host, Mike Leon. Deb has spent more than 2 decades helping families, retirees, even small town business owners find clarity, peace of mind, and practical solutions through thoughtful estate planning. Today's episode, we're going to be breaking down wills and trusts in plain English. Deb's going to explain what they do, how they work, how they differ, and how everyday New Hampshire families can decide what really fits their needs. Deb, it's good to see you. And since this is the first episode in this podcast series, tell us a little bit about your background, how you built your practice up in Henniker, and what led you to focus so much on your work on estate planning for New Hampshire families.
Well, thanks for having me, Mike. And it's a pleasure to be here with everyone. So like you said, I've been practicing for 23 plus years. And really, I brought my practice from being a practice with, a joint practice with other people to a solo practice. I've been solo for about 12 years. And I wanted to be solo for a number of reasons and practice in this area because I love people. And I love the flexibility that this gives me to have time with my clients, to be able to spend time sitting and really processing through what plan do people need and why do people need estate planning and what is right for their family. My practice it allows me to spend quality time with folks, and I love that. And Henniker is a great town. We're just a small town in sort of the western part of New Hampshire. But I draw clients from a lot of places because they want that hometown feel. They want to feel like they are getting personalized service. And so it's a great practice area. And I love hanging out with my clients, and they like being here too. So it's great.
Well, let's get into why they reach out to you. So I mentioned before about wills and trusts and in plain English. So how do you explain what a will actually does and what's its main job?
Sure. So a will is simply an agreement or a piece of paper that somebody signs that says who's going to get what when they pass away and who's going to manage all the paperwork pushing. And, that sounds simple and maybe a little flip, but the truth is somebody has to manage all the bills and the final arrangements, and somebody's got to take the assets and get them put into one place and then distribute them to family members or friends or whomever the beneficiaries are. So a will is just a way for people to communicate that to their loved ones, to their beneficiaries. And so that's what that is. So.
And let's move over to trust. I mentioned trust in the intro as well. So let's talk about a revocable living trust first. What makes that useful for regular families?
Sure. So I love revocable trusts. I tell all my clients, it's like a basket, and you put all your assets into that basket. When you pass away, the basket gets handed to your heirs and does not go through the probate process. So the big advantage of a revocable trust is it avoids probate completely, as long as you get all your assets into the trust. If you don't get them all in there, some have to go through probate. But with a will, you always go through probate. With a revocable trust done properly, you can avoid the probate process.
Deb, let's explain a little further about some of the differences between the will and the trust. Like, what tends to be the biggest difference between relying on the will part versus setting up a trust-based plan for folks that have bank accounts, retirement savings? Break it all down for us.
So really the difference is, for my clients, it's in cost. They don't want to spend the money for a revocable trust, so they just go with a will package, which is fine. A will is everybody should at least have a will because it directs what you want to do with your assets. Otherwise, we have to follow a statute of intestacy, and it says who gets what. So everybody should put down in a will, properly executed, what they want. And so for my clients, if they just want something simple, or they feel like their assets are jointly owned with someone else, or they don't really have anything other than a bank account, a will really is fine and it will work for them. And the bank account being a jointly owned bank account. But if somebody has the basics, they've got, like you said, bank accounts, they've got retirement, they have a home, having a trust, it doesn't take a long time for us to do this or to draft it. They just come in, They tell me what they want. I put it into the proper language that, the court and everybody else wants to see. We get that drafted for them, and then their heirs know exactly what they wanted. And I do a number of documents that go with that. We always do the will or the trust. And even if somebody has a trust, we always do a will that goes with it. And then powers of attorney for finances and powers of attorney for healthcare, also called an advance directive. And I also do a form called a final disposition, which just tells folks, hey, when I pass away, I would like to be buried or cremated or all the other options that people have now. So that's sort of the difference between the two plans.
Deb, the key words that you just mentioned there are plans and planning, right?
Mm,
So,
very
without getting into potential specifics of clients, is there a story that you can maybe share that
much.
illustrates how having all of these right documents in place and the planning makes things smoother for the loved ones out there?
Absolutely. So this summer I did some planning for a couple, and um, they maybe just in their middle 60s, so not in a space where we had any um, kind of any anticipation of something happening. But they came in, did their trust, did their pour over will, did all their documents, and then unfortunately, unexpectedly, a few weeks ago, the husband passed away, and so now that that's happened, the wife came in, we sat down with all of her documents, we went through all the planning that they had done, and it was such a relief. It wasn't one more thing she had to worry about. It was, wow, we already took care of this. We know that our assets are in the trust. She was obviously the main beneficiary of everything, being a spouse, but nothing was left out. So there wasn't a car that needed to be probated. There wasn't a checking account that was loose that we had to gather up and run through probate. It was all done. And so really her biggest things are to focus on her grief and getting through this, the final arrangements and making a funeral plan and all of those things. But it wasn't on, oh my gosh, how do I get a hold of the checking account so I can pay the car payment, so I can do whatever needs to be done. It was all taken care of. So all of the paper piece of somebody passing was all done. So there was a lot of relief. And then she actually came in and said, maybe I want to make a change or two to the trust and to the things that we were going to do, because I wasn't planning for being alone at this point in my life. And I said, hey, easy to do. And the beauty of a trust, right, is that we can amend it at any time with a revocable trust. And so we're planning on some amendments, and she'll be continue to be all set for what she needs. So
Yeah.
yeah,
Well,
it was
Deb, even in that example, and you could use that example, or you could use another one.
sure.
People are overwhelmed, right, by the decision process, especially between maybe, let's say, a will and a trust. How
Absolutely.
have you helped them sort out whether they're better off with a simple will package or a
Mhm.
trust that avoids, like you said, court involvement with probate down the road?
Mhm. So a lot of times folks come in and everybody says, well, maybe I did something on the internet or I wrote something down, or they have an idea about what they want for their estate planning. But sometimes then they're a little bit stuck between the decision between a will and a trust. And then we run through what it looks like in New Hampshire if you have to go through probate. So if you have no will or a will, you're going to go through probate. If you have a trust, you're not going to go through probate. So we just talk about that. We talk about their assets and what it looks like to have whoever is the last person standing, whether it be a surviving spouse or the children. What does it look like and what do they need to do? And so we walk through, what does that look like? We gather the assets. If it's just a will, we talk about the probate petition, and I talk to them about the process. And probate in New Hampshire it's a slow process. It's not awful. It's not terribly involved, but from the time someone passes to the time that you're done probating, it's probably 15 months, maybe 16 months or more. So that's a long time for people to be having to dwell on um, paperwork and wrapping up someone's estate if they If the client chooses a trust, then things can be wrapped up much quicker. So we talk about that. We talk about just their goals and who they're planning for, because some folks are planning for a child, in the home, or more than one kiddo, or they have a special needs child. Even if they're over 18, they're trying to plan to maintain assets for them. So there's a lot of things that people look at when it comes to what kind of document they want to do.
Yeah. Deb, as we put the final bow on this episode, for the listener out there, they're listening to this right now. Maybe they aren't sure of what they even have, or if their old
Mhm.
documents still work. What's
Yeah.
a simple way you would recommend for them to review it and figure out if it's time to update it?
Sure. So that is a great question. And I tell everyone, at the very least, I think it's wise to review your documents every 5 years. There's a little bit of a trend that I'm seeing with folks, if they need to use a power of attorney. So someone's alive, but they're doing finances for someone else with a POA. I'm seeing banks be really nervous to accept POAs that are over 5 years old. And it's not that they really have a right to refuse that power of attorney, but they are just worried because there is a lot of fraud out there. So I tell folks, take a look at your documents. At the very least, we should redo your power of attorney and make sure it's up to date every 5 years. And then, really, if something has changed, if someone has retired, if a spouse has passed away, if the kids are grown and flown and doing well, or if you have a kiddo that maybe has reached adulthood and is struggling, whether it might be an addiction issue. We have such a problem with that here in New Hampshire. And so there's a lot of parents worried about handing money to a child who's struggling. So, those are things that we talk about. And so those things can change over time. And if that's something that, their documents were prepared in the first instance with that happening, maybe now it's time to change them. So all of those things are good reasons to change. And honestly, coming in and sitting down and just having a cup of coffee and talking about the documents, it's a good idea just to redo or relook at everything.
Yeah. Deb, thank you so much for the time and insights,
Yeah.
introducing yourself to the audience. I truly appreciate it, as always.
Thanks, Mike. It's really good to be here, and I'll see you next time.
And that wraps up today's episode of Planning with Purpose. If you live out in New Hampshire and you want help figuring out which tools kind of make the most sense for you and your family, you can connect with Deb and the team over at courteouslaw.com. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.